Good evening, everyone, to this first session under the Vijaybhoomi e-colloquium on law and economics. Under this series, we will be deliberating issues at the intersection of law and economics, which inform legal and administrative proceedings in various walks of life. But today, before I welcome my guests of this evening, I must compliment this gathering of 100+ brave hearts who have come together to discuss a topic like market delineation in digital markets. That's something commendable, and my compliments to all of you. I now turn your attention to the first guest, the presenter of this topic this evening. Professor Viktoria Robertson is an associate professor at the University of Graz, where she teaches EU competition law, comparative competition law, and commercial law. Starting September 2020, she will be holding the chair in commercial law and digitalization at the Vienna University of Economics and Business. She has a doctorate from the Graz University and a master's degree from Oxford University. She has been a researcher at the Max-Planck-Institut, the College of Europe, the European University Institute, Stanford University, FGV Rio Law School, and Oxford University's Center for Competition Law and Policy. Her current research focuses on market definition and digital market environments and excessive data collection through online platforms as an abuse of dominance. In fact, I recently saw your working paper on that, Vicky. Welcome aboard, Vicky. Let me present all of you the first discussant of the topic today, Mr. Manas Chaudhuri. He is a very well-known competition lawyer in India and abroad. He advises Indian and overseas clients on competition law and policy. I have known Manas for more than a decade now as a competition lawyer. I know that he has been civil judge in the West Bengal State Judicial Service. And prior to that, he has been also engaged with the MRTPC, the earlier avatar of Competition Commission, and then thereafter with the Competition Commission. And then he has been having a very successful competition practice. And you can see him in almost all major competition law events, whether in IPBA Vancouver or Auckland or Manila or ICN or BRICS Competition Law Conference. Everywhere you can meet him and interact, and he is there to express his views. And most recently, Manas has co-authored an article entitled The Genesis and Ailments of Cartel Regime in India, a critical analysis, which has been published in Indian Law Review. If I can put it, I know I'm slightly biased, but I can say, Manas, that you are a walking encyclopedia of competition law in India. You have seen the law growing in this country. Can I ask you a general question? In the meantime, Vicky adjusts her audio setting.
Can you hear me now?
Yeah. Yes, yes.
Okay,
So let me get back to Vicky first because I introduced you first. So what is your association with the whole philosophy of competition? To me, it is a very, very enlightening thing. But what does it mean to you, Vicky?
So obviously, as a competition law researcher, competition law is what I do. It's really the air that I breathe. And that's why I thought that the last colloquium we had with Ariel Ezrahi and Maurice Stuckey was so refreshing to actually see a different perspective. I think that's very important.
Right, right. Manas, you have been faithfully wedded to competition law, competition thought. What is the attraction?
Navneet, first and foremost thing is that I joined this practice or started this practice by default. So in fact, it was emerging concept in 1999, 2000. That is the time, I just been roped into the entire concept of introduction of the Competition Act. And it was so fascinating that one tends to know the industry so well. Once you are a practicing lawyer or an economist of competition, you would tend to know how difficult it is to run a business and how difficult it is to meet the challenges of a Competition Act when a regulator is empowered with terrific legislative powers to implement and enforce the competition law. It's a very difficult balance, and a professional who has to strike it for his client, and also before the regulator on the ground that the regulator is also controlled by the enactment which has been passed by the parliament. It's a very challenging and a fascinating journey. But at the same time, it's wonderful to know how businesses run and how do you really make the business profitable without harming the stakeholders, including the consumer. That's my take about the subject.
So the enigma of business is what has kept you attracted to competition law. Well said, Manas. And my second discussant for the topic today, Dr. Vikas Kathuria, is the Senior Research Fellow at Max-Planck-Institut for Innovation and Competition in Munich. He earned his PhD degree at the Tilburg Law and Economics Center, the TILEC, in Netherlands. His PhD thesis investigated the role of competition law in fostering innovation in emerging markets. Vikas has previously worked with the Competition Commission of India and has also taught at the Jindal Global Law School. Vikas, if I can ask you a question to begin our conversation, what drew you to the field of competition?
Well, as it happened with Mr. Chaudhuri, it was just coincidence. It was a coincidence. I wanted to work on international trade, but I just happened to work on competition law. And why I stayed on, because it's amazing. It's amazing in the sense that it is counterintuitive, as all economic laws are. You come up with a different answer every time when you apply economics. So for me, competition law is a gateway into the realm of law and economics. And that's why I love it so much.
All right. That's fair enough. To now introduce the subject, as all of you know, digital platforms play a central role as facilitators of online interactions and transactions between users. In the current market context, digital delivery of goods and services has already assumed great significance. Therefore, this deliberation today on an important methodological struggle in assessing market power. This equilibrium today will discuss digital platform as an instance in which market definition encounters a number of important challenges. The discussion has gained significance in the wake of recent announcements. If you have taken a note of starting from the EU Vice Presidency on Competition, the DG Comp, the US FTC, India CCI, and several other competition authorities have announced a review of the digital space. Competition authorities and courts are increasingly concerned also with merger and abuse cases that involve digital platforms. I'm just trying to give you a general state of the play. In today's discussion, we will try to engage with important questions as to how to define markets and how to assess market power while dealing with two-sided platforms. We shall also try to touch issues like multi-markets approach versus two-sided markets approach, the recognition of the zero-price markets, the relevance of homing decision of users, and the utmost importance of assessment of entry barriers in today's discussion. We will try to see that how best we can utilize the next hour very, very meaningfully. But let me start this session, let me start the discussion today by inviting Professor Robertson to talk about her recent book, Competition Law's Innovation Factor. It looks like a Bollywood movie title. Nevertheless, Vicky, I invite you to explore, what are the important challenges or controversies from the comparative legal perspective, taking into account both EU and US antitrust laws, which you have found out and has captured in your book. Over to you, Vicky.
So thank you very much. I hope you can see and hear me now.
Yes.
Great. So it's really great to be here at today's ecolloquium. Thank you so much to Navneet for inviting me. Thank you to Vikas and to Manas for agreeing to contribute their input. What I want to do today is look at how we can define relevant markets in our digital times. And as Navneet already pointed out, I thereby rely on the book that I recently published with Hart Publishing Oxford. I want to start with a brief look at our current European framework for market definition. And as Navneet also said, in my book, I deal with US antitrust law in detail as well. So if you're interested in that, then go and have a look in the book. So 10 years ago, Louis Kapleau wrote a very influential article called Why Ever Define Markets? And the answer, I believe, is quite simple. We need the relevant market as a frame of reference for our entire antitrust analysis. And I'd like to show that to you by looking at the functions that the relevant market has in EU competition law. And there's two of those functions. The first is what I call the market power function. And the second is what I refer to as the market characterization function. So for the market power function, let's start by looking at Article 101 of the Treaty on the Functioning of the European Union. This article prohibits anti-competitive agreements, for example, price cartels. And here the European Commission has issued binding block exemption regulations that have market share thresholds. And for certain types of agreements, they're block exempted if they don't go beyond the market share. And the underlying assumption, of course, is that this indicates a lack of market power. The European Commission also issued a lot of non-binding guidance, like the de minimis notice, and those also have market share thresholds. Then we have Article 102 of the treaty, which tells companies with market power that they may not abuse their market position through certain types of anti-competitive behavior. And here the Court of Justice has established the so-called AXO presumption that a company is dominant within the meaning of Article 102 from a 50% market share. So again, market shares. And we also have the merger regulation, which checks whether a merger between companies may lead to the creation or strengthening of market power. And that's the same kind of market power that we look at under Article 102. And for instance, we have guidelines on horizontal mergers that also like to calculate concentration levels, for which you also need market shares. So that's the market power function. Now, the second function is what I call the market characterization function. And here, the Court of Justice has for a long time told us that under Article 101, we need to appraise agreements in their economic and legal context. And we also need to know about the market to assess an individual exemption. Under Article 102, but also under the merger regulation, context is equally important to either understand an abuse or to understand how competition is working in a certain market, either where there's dominance established or where there's some being created, or even if not, under the merger regulation. So that's the state of play. What is the current EU framework for market definition? So here I just refer to some rather old cases as well, where the Court of Justice has told us in Continental Can that the definition of the relevant market is of essential significance. It said we can only judge the possibilities of competition with reference to a relevant market. And of course, it referred to demand and supply interchangeability. Now, the European Commission in 1997 issued its market definition notice, where it tried to summarize the case law, but also added its own interpretation of what a relevant market is. Now, in general, both the court and the commission, they rely on supply and demand side substitution to define markets. And the notice operationalizes that through the SNP test. Now, one issue is that market definition in those cases and how it developed was really modeled on traditional static markets that are characterized by incremental innovation, if any. So let's now turn to what we're here to discuss, the digital markets. What are the characteristics of those digital markets that challenge traditional market definition? And this list of characteristics, of course, does not apply to all digital markets. So it is a stylized view of a product market that could relate to e-commerce or online advertising, internet search, social networks, the collection and use of big data, and so on. And of course, that includes the GAFAM, which is why they're on the slide here. But it's so much broader than that. So what are the features of the digital market? The digital market is very often fast moving. There are short product cycles. And so market boundaries need to be questioned on an ongoing basis. Those markets are often also innovative and dynamic, or what we could also call Schumpeterian after the Austrian economist Josef Schumpeter. So there's not only incremental, but actually radical innovation that overthrows old market orders. And that also leads to inherent uncertainty in those markets. What are the features of the digital product? Products in digital markets are often differentiated, and they have constantly evolving functionalities, which makes it difficult to establish what interchangeability might be sufficient for market definition purposes. We also witness something that's like a seamless integration of technology and of markets. So more and more products actually become interoperable, and that can soften the boundaries of the markets. Now, finally, let's look at the dynamics of competition in those digital markets. We often have multi-sided platforms, as Navneet already pointed out in the beginning of the talk. They're very present in digital markets, but of course, we know this phenomenon of platforms from other areas like credit cards or newspapers that are partially financed through ads. But the digital realm really takes multi-sidedness to a new level. Then we have direct and indirect network effects. For instance, if there's more of my friends on a certain platform, a social media platform, then I want to be there too. Those are the direct network effects. But the more users like me and my friends are on a platform, the more advertisers are also interested in being on the platform as advertisers. Those are the indirect network effects. This can lead to a lock-in of users, but it also means that those markets might be prone to tipping, so that the demand concentrates on one platform, then the market tips, and once it has, it's very hard to do anything about the cemented market power. And finally, user data. User data plays an important role for the business models of many digital platforms. And here it's really crucial to underline that lots of this data is very versatile, can be used in very many different ways by one and the same platform. So this is to set the scene.